Luigi Mangione is fighting for his life in not one, but two simultaneous jurisdictions in New York, the state of New York versus Luigi Mangione, and the federal government, the Southern District of New York versus Luigi Mangione, the United States. And in those cases, we're now going to see what the defense's legal strategy is for Luigi Mangione. And this legal breakdown, again, I'm not a lawyer, but I'm going to break it down to you in detail on what I believe the legal strategy is in Karen Nifolo's essentially new motion to dismiss the federal case. I'm going to explain how it works, what it means, what I think the legal strategy is from my own personal opinion. This is a really good document, not so popular of a topic. We'll get into that. The devil's in the details. Let's go. Now, in case you've been hiding under a rock all this time, Luigi Mangione is the alleged shooter with the presumption of innocence until proven guilty in a court of law. Let's not forget that. Brian Thompson, the CEO of United Healthcare in December of 2024. Now, the case is proceeding very, very slowly, and now there's been a big ruling, there's been a big suppression hearing about whether or not the arrest of Luigi Mangione in Altoona, Pennsylvania, 5 days after the shooting of Brian Thompson was legal or not. Now, this document filed yesterday by Karen Nifolo on behalf of Luigi Mangione is in the Southern District of New York. This is the federal case's argument. So for those of you who are confused, like, hey, is this in response to what just happened in the state case? No, it is not. This is a different case. This is the Southern District of New York. Now, I'm going to break down for you in detail what I've believed for a long time is the legal strategy. And it's not going to be the most popular opinion among people who are Luigi supporters, but I believe in being fair with this case. And I think you're going to learn a lot about the law. And I think that you hopefully will listen to my points, because we are about civil liberties, constitutional issues, making sure that we do things right. If you're going to execute someone by using the law, then you should probably obey that same law in your process of trying to execute someone. And that's the bottom line of this legal defense. So bear with me. Here we go. Now, I want to show, in case you haven't seen it before, this is Luigi Mangione's website, luigimangione.info.com. This is where you can see a lot of information. This is put together by his attorneys on his case. And here I'm trying to get my mouse to quit having a cord in the way. On this page, you will see this red highlight. In the federal case, there is a reply filed 12/19/25. That's what we're going to get into. There's the state of New York case. There's the Commonwealth of Pennsylvania. Like I said, there's three different jurisdictions that want Luigi Mangione. We're going to focus on this reply filed on 12/19/2025. Now, this is going to be, for some of you, dry because it's a legal breakdown. We're going to talk about a legal document that I'm going to put on screen right there. There's the legal document. Let's see if we can clean this up a little bit, make it as big screen as we can. I'm going to be reading to you large portions of this document. This is actually a three-pronged argument on the defense's case. They're arguing that you need to drop the case against Luigi Mangione on three basic principles. We're only going to cover two of them because it's a long document. It's 51 pages long, and I tend to read a lot of what Karen Nifolo says because she's a master at writing argument. I think her argument is not only super well written, but also 100% flawless, in my opinion. I think it's perfect. But will the judge see it that way? Will they rule what should be the right way? Let's break down the legal document and the argument. Now, before I get into the actual writing that she says and the points that she makes, I want to tell you what I've said for a while that's not going to be the super popular opinion. If Luigi Mangione did it, and let's never forget that he has the presumption of innocence until proven guilty in a court of law. If Luigi Mangione did it, then what Karen has argued is it's unfair to her client to have to face two different jurisdictions, the state of New York and the federal government, the United States versus Luigi Mangione, at the same time. Because in order to give a proper defense in one case, it could prejudice you against the other case. This is the nuance that many people do not like. Because what I've said from the very beginning is, if Luigi Mangione did it, there is a way that this case could put the American healthcare system on trial. And while I've had some attorneys say that's a real long shot that they're going to put the American healthcare system on trial, because again, any prosecutor is going to say, Your Honor, the healthcare system is not on trial here in this trial. It is whether or not Luigi Mangione shot this man, plain and simple. And I believe that the judge would more than likely uphold that. However, there's one nuance, and I've explained it many times, in which if you have only the state case, you could argue a manslaughter charge and not even get life in prison without the possibility of parole. You could end up facing something like 5 years as a maximum sentence with time served. So it could make a massive difference if you take the death penalty off the table, if you take first-degree murder off the table, which, by the way, first-degree murder has been taken off the table in the state case. It's a lot of nuance. So I feel like I'm boring you already. We got to get into the legal document. So the point being is that Karen's going to lay out 3 arguments. I'm only going to deal with 2 today because they're quite lengthy, but they're really, really good. And there's new bombshell information. I should have led with this. There's new bombshell information about Pam Bondi and why this whole case needs to be dismissed. And so that's why I titled this thumbnail Motion to Dismiss, because essentially what Karen Nifolo is going to ask is toss the entire federal case out. And let me reiterate one last time why that makes a difference. If the federal case is 100% tossed, then all Luigi Mangione will face is the state case against Luigi Mangione, of which first-degree murder has already been removed, which would leave only one thing for Luigi Mangione to fight, which is second-degree murder in the killing of Brian Thompson. If it is reduced, if the federal case is gone, and all you have is second-degree murder charge in the state case, there is a defense strategy that could put, in essence, the United States healthcare system on trial. How? Because it would leave the option in the second-degree murder case for arguing, yeah, maybe our guy did it, but you have to understand why he did it. And if you understood why he did it, then you can offer leniency and call it manslaughter. It's similar to the I caught my wife in bed with another man, so I lost my mind and I killed him. Yes, I killed him, but if you understood the story, maybe you would take sympathy and realize maybe a lot of people would have done that in the same situation. So that's the nuance. I hope you understand. Let's get into the legal document. I've taken too long, way too long of a preamble. 6 minutes is long enough. All right. This is the United States District Court, Southern District of New York. That is the federal case against Luigi Mangione. And again, this is not anything to do with Judge Caro's recent suppression hearings that took place on whether or not the arrest was illegal. Ultimately, I believe you're going to find that the arrest in Pennsylvania was illegal, and they're going to mention it. This argument in the federal government does talk about why the arrest was illegal in Pennsylvania. And that is what we were just talking about in the state case. So you're very confused. I get it. Like if you're not following this case closely, you're very confused. Wait a minute. Thought you said it wasn't about the state case. But bear with me. I'll explain it as we get there. All right. Defendant Luigi Mangione's reply in support of his motions challenging the constitutionality of the death penalty, moving to dismiss counts 3 and 4, and moving to suppress evidence and statements. So this is a motion to dismiss entire parts of this case, and we're going to break it down for you now. And it's a really, really good argument. All right, we're going to get past the table of contents, which is quite lengthy. There's a lot of legal documents and court filings that are referenced. You can see a whole table of court documents that they reference to show the judge the legal standing. Here's the reply memorandum. This is how we open, and let's go. Defendant's reply memorandum addresses 3 issues. 3. We're only going to cover 2 in this thing. First, the government has failed to rebut the defendant's factual assertions of prejudice as presumed by Local Rule 23.1 and as established by the actions of Attorney General and others. Second, stalking is not a crime of violence. And third, the defendant's motion to suppress evidence should be granted. Okay, of the 3 issues, we're going to deal with 1 and 3. 1, we're going to deal with Pam Bondi, the Attorney General of the United States, claiming on national TV that Luigi Mangione is a murderer of an innocent man and needs to be put to death because that's the only thing that makes sense. That's the first argument. She's going to say that was bullshit. You can't fucking do that all day long. Oh yeah, whenever I say F word, whenever I say the F word, I'm reminded to put the parental advisory in the corner. There you go. So when Pam Bondi took the bully pulpit to talk to the public and tell people that Luigi Mangione is guilty of murder of an innocent man and deserves to be put to death, that was a major mistake. And that's why Karen's saying you must dismiss on that alone. And there's other reasons as well. Then she's going to say basically stalking charges are not a crime of violence. We're going to put that aside. It is a very nuanced thing. Most people will not understand it. I feel like it's going to snooze fest most of you. So I'm going to choose to put that aside. Even though it's a big argument, it's a major part of this document. We're going to put it aside. And then the last one, the defendant's motion to suppress evidence should be granted. Again, that's what we were talking about in that state case. That arrest in Altoona, Pennsylvania was illegal. His lawyers have said it's illegal. They had 2.5 weeks of suppression hearings or so talking about whether it was legal or not. And the judge is going to rule on that in the state case on whether it was legal. It was not legal, in my opinion. Now, whether the judge rules that way or not, that's a whole other issue. But she's going to make the argument again that was an illegal arrest, and you must toss the evidence that came out in that arrest. All right, let's get into the details, because the devil is in the details, remember. Point number one, the notion of intent should be stricken because prejudice has been established. The defense's motion challenging the constitutionality of the death penalty, as applied in this case, focused on the unprecedented, repeated, and prejudicial actions of the Attorney General. Here, the Attorney General herself has violated the rules of this court and the Department of Justice procedures. The Attorney General personally directed line prosecutors, meaning those people underneath her, to seek the death penalty in a public press release delivered via social media, and then appeared on national television to claim that, based on her own experience as a capital crimes prosecutor, Mr. Mangione deserves to be executed. That's a major fucking problem. Karen Nifolo has pointed out that's a major fucking problem over and over again, and she's going to lay it out one more time in her motion to dismiss, but it's got some key new bombshells. So listen. The defense previously argued, so this is Karen saying, hey, we recently have told you already. The defense previously argued that the Attorney General took these unusually personal and prejudicial actions to ensure that Mr. Mangione's case was the first death-eligible case of the new administration, meaning Trump's administration, his second administration. So it was the new administration because, remember, Trump got voted out of office, and then he had a time where Biden was in charge, and then he's back in office again. When he took office again, she said, hey, look, we're going to be done with that pussyfoot and shit that Biden did, not putting people to death. We're going to go back to putting people to death. Trump has ordered me to execute criminals, and I'm going to do so. And Luigi Mangione is our poster child. That's the summary of what Pam Bondi said. Now that Trump's back in office, we're going to put those pussyfoots away that don't want to execute people, and we will start executing again. And Luigi Mangione is our poster child of the first person we're going to execute per Donald Trump's directive. That's the summary of what she said. And yes, that's my personal opinion. It's also Karen Nifolo's personal opinion, as you'll see in the writings. Now, prior to her appointment, this is where the bombshells come out. Prior to her appointment as Attorney General, Miss Bondi was listed as a partner of the lobbying firm Ballard Partners. Holy shit. This is like, I wish I would have led with this. Like, I'm a moron. I buried the lead. This is the critical piece. Pam Bondi has a financial incentive to execute Luigi Mangione. That's essentially what they're going to say. And wait till you see the evidence. This did not come out at first. This came out after Karen Nifolo started pressing and looking for more details. And this is what she found. And it's a shocker. Prior to her appointment as Attorney General, Miss Bondi was listed as a partner of the lobbying firm Ballard Partners. In turn, Ballard Partners lists United Health Group, UHG, as a regular client of the firm. The Attorney General delivered and continues to receive personal benefits from Ballard in the form of profit sharing plan from Ballard's professional association with all of its paying clients, including UHG. What is she saying? Pam Bondi financially has a reason to protect the reputation of United Healthcare, who's the subject of this entire case, because she financially benefits when United Healthcare does better, and she financially takes a hit when United Healthcare does not do better. Therefore, Pam Bondi has a conflict of interest overseeing and making opinions about who's guilty of death in a murder of a United Healthcare personnel or CEO, because she's financially tied to the outcome. These benefits, continuing with Karen's argument, these benefits, along with the financial benefits of the Attorney General that has derived from Ballard while she was a partner and while the partnership divided up revenue from UHC, shows that the Attorney General has a personal and financial interest in the work that Ballard has done on UHG's behalf. Now, again, I don't want to get huge into this, but United Healthcare is owned by United Health Group. So you're going to see UHG, United Health Group, instead of UHC, United Healthcare. But you have to understand, United Healthcare is a daughter company of United Health Group. So United Health Group is related to the financing because it owns United Healthcare, or it's a daughter company. United Healthcare is a daughter company of UHG. Further, as the chairperson of Ballard's Partners Corporate Regulatory Compliance Practice, the Attorney General, so Pam Bondi's a chairperson of this stakeholder group in United Health Group. So it's a major problem. So as a chairperson of Ballard's Partners Corporate Regulatory Compliance Practice, the Attorney General knew, or should have known, that UHG, the largest and richest healthcare company in the world with annual revenue of $400 billion, annual revenues of $400 billion was one of her partnership's clients, and that she personally financially profited from Ballard's lucrative relationship with UHG. We are talking about $400 billion in profits on that company, and Pam Bondi gets a share of it because she's in part of an investment company that makes money when UHG is making money and loses money when they lose money. Follow that logic. It's a major conflict of interest. It gets worse. When Miss Bondi left Ballard Partners to become the Attorney General in 2025, the very first defendant that she personally selected to be executed was the man accused of killing the CEO of her former client. Do you see the problem? Like, literally, the first person you go after as Attorney General when you're appointed is a person who killed the CEO of a company you're financially tied to. The Attorney General's financial connection to UHG represents a conflict of interest that should have caused her to recuse herself from making any decisions on the case. In other words, she should have said, look, I can't talk about this case. I'm too closely tied to it. But she did not do that. And that's a major problem. Her failure to do so clearly violated the due process rights of Mr. Mangione and provides yet another reason why the notice of intent should be stricken. Now, what is the notice of intent? Pam Bondi asked basically the Southern District of New York to file a notice of intent to execute Luigi Mangione. She told them to do that. You will file a notice of intent that you intend to execute Luigi Mangione. So what Karen is saying is you must strike down the notice of intent. You must take off the table that you plan on executing Luigi Mangione. In fact, she'll make an argument that the entire federal case should be dismissed. Now, I'm going to read this footnote here, and maybe out of order because I can't remember exactly how it goes, and I tried to use two different highlightings, and I didn't do it. But let's continue this. Footnote to why the notice of intent should be stricken. This reply is limited to the due process implications of the Attorney General's actions personally directing the Department of Justice to seek the death penalty for the alleged murder of a former client's CEO. The defense will move separately to address the profound conflict of interest implications of this situation. As part of that motion, we will seek discovery, including but not limited to all communications between UHG, UHC, and Ballard Partners with any employee or representative of the U.S. government relating to this matter. The terms of Mrs. Bondi's compensation from Ballard, including the revenues that Ballard derived from UHG and UHC, how that compensation was divided among Ballard's partners, including the Attorney General, all information and communications touching on the relationship between the Attorney General and her clients, UHC and UHG, both while the Attorney General was employed by Ballard and since that she's assumed her office, and any direction the Attorney General has provided to any other Department of Justice employees regarding this matter, UHG, UHC, and Ballard, since she has assumed office. That is a big, long paragraph, but what it says is Karen Nifolo intends and is asking to see all communications between all of these entities to show Pam Bondi, how much money Pam Bondi is making with her relationship to UHG, how much of UHG or UHC's communication took place with the federal government to decide and inform whether or not they should execute Luigi Mangione, all of the conflict of interest stuff. Because again, I believe Karen Nifolo knows damn well those discussions took place, that there's a financial incentive to execute Luigi Mangione. And that's why she's saying you must dismiss. You must dismiss this because you have a financial and you already fucked up. You done fucked up a long time ago. Now, the Attorney General's association with Ballard and Partners and Ballard's association with UHC violated Mr. Mangione's due process rights. This is point A. Ballard Partners is a lobbying firm specializing in government and public affairs. The firm has a close relationship with the President of the United States and the current administration. The founder of Ballard Partners served as the 2016 Trump campaign's Florida chair, as a Trump pledged Florida Electoral College elector, and as vice chairman of President Trump's inaugural committee. So what they're saying is this group that financially benefits from UHC or UHG's money-making machine of $400 billion a year, it directly funds Trump and Pam Bondi and people in his administration. After serving as the Attorney General of Florida, the Attorney General joined Ballard Partners in 2019. This is talking about Pam Bondi's history, and this gets crazy. After serving as Attorney General of Florida, the Attorney General joined Ballard Partners in 2019. In November of 2019, she left briefly to represent President Trump in impeachment proceedings and returned to Ballard in January of 2020. She continued as a listed partner with Ballard Partners until the very day of her confirmation as Attorney General by the United States Senate on February 4, 2025. In addition to being listed as a partner, the Attorney General was the chairperson of Ballard's corporate regulatory compliance practice. In a publicly filed financial disclosure report, the Attorney General stated that she will, quote, continue to participate in Ballard Partners' defined contribution plan, even after becoming Attorney General of the United States. Accordingly, the Attorney General currently has some of her personal wealth in a financial contribution plan administered by Ballard. So in other words, Pam Bondi's own retirement plan is funded in part by how successful UHG or UHC is. So it's a conflict of interest to be giving opinions about who should be or shouldn't be murdered or executed in the commission of a crime against United Healthcare when you financially benefit from that result. UHG has been a client of Ballard Partners for several years and remains a firm client. Indeed, Ballard's website includes UHG as a current client of the firm. It appears that UHG was a client of Ballard from at least as early as 2023. In 2024, UHG paid Ballard Partners at least $250,000 or $250,000 for lobbying services. And in 2005, so far, this amount has increased 80% to about $500,000, $450,000 in lobbying on behalf of UHG. These figures alone indicate that following the murder of the United Healthcare CEO in December of 2024, UHG almost doubled its lobbying efforts by the very firm that had previously employed the Attorney General. Listen, that's huge. So Pam Bondi gets appointed as Attorney General, and all of a sudden, UHG is pumping a bunch of money into execute Luigi Mangione, who killed our CEO, because it's in your financial best interest and in our financial best interest. This is the argument that I think Karen is laying down extremely well to anybody who has 2 cents of a brain to follow the logic. Because the Attorney General was continuing to work at Ballard Partners as a listed partner during the years when Ballard was taking money from UHG, she would have derived personal revenue, both directly as income and through Ballard's profit-sharing plan that originated with UHG. To this extent, the Attorney General personally and financially profited from Ballard's connection to UHG, and she continues to do so. This is the enormously great way. I mean, I understand the nuances of legal writing might be a little bit rough, and maybe I could have said this easier, but I love reading Karen Nifolo's thing because she makes it spelled out in a way that cannot be ignored. It's not just like, hey, I think she profited financially. She's like, no, I know she does, and this is how I know it, and I'm going to find out exactly how much money she got. Like, she's going to cross all of the T's and dot all the I's. On January 14th, 2025, the Attorney General signed and delivered a letter to the designated Ethics Office with the Department of Justice. Among other representations, the Attorney General stated, and this is huge, January 14, 2025. Brian Thompson was shot and killed. I was going to say Luigi Mangione allegedly shot and killed him, but let's take that out of the equation. Brian Thompson was shot and killed December 4th, I believe, of 2024. After that, a month later, January 14th, the Attorney General signs this letter with this statement. This is the statement that she signed. Upon confirmation, that's of the U.S. Attorney General, I will resign from my position of Ballard Partners pursuant to the impartiality regulation of 5 CFR section 20, whatever. For a period of 1 year after my resignation, I will not participate personally and substantially in any particular matter involving specific parties in which I know Ballard Partners is a party or represents a party unless I am first authorized to participate pursuant to 5 CSR and the big huge section number. In addition, I will not participate personally and substantially in any particular matter involving specific parties in which I know a former client of mine is a party or representative a party for a period of 1 year after I last provided services to the client unless I am first authorized to participate pursuant to 5 CFR. What is that huge paragraph saying? Pam Bondi, when she was about to be Attorney General of the United States, said, by the way, if I get approved to be Attorney General, I will not participate in anything that has to do with my former position as a Ballard partner, financial representative. I won't take any actions and anything that has a conflict of interest. She said that. I will stay away from having any potential conflict of interest for 1 year unless I'm personally authorized to do so. Now, there's the caveat that they're going to try to lean on, right? Maybe she was personally authorized to do so. The point being is that Pam Bondi knows, she knows damn well, and she signed a statement that said, I will not litigate. I will not get involved. I will not make opinions on a case that involves potentially a conflict of interest in Ballard Partners. That's what that statement says. During the first several months of 2025, the Attorney General's prior firm, Ballard Partners, intensified its lobbying efforts on behalf of its client, UHG, with the U.S. government. Again, remember, they went from contributing $250,000 a year, $250,000, to $450,000 a year, or $500,000 after Pam Bondi, one of their representatives on their board of directors, gets appointed U.S. Attorney General. And now all of a sudden they're flooding in twice the money that they used to flood into the campaign, or to lobbying. So isn't that interesting? I hope that you understand how money works. During this same period, specifically on April 1st, 2025, the Attorney General took the remarkable and unprecedented steps of personally and publicly ordering line prosecutors to seek the death penalty against the man accused of killing United Healthcare's CEO. So, again, let's follow this logic real quickly. In January, she swears that she won't have anything to do with any conflict of interest between Ballard Partners, who one of their major shareholders is United Healthcare or United Health Group. And then in April, just a couple months later, she makes a public statement doing the very thing she promised she wouldn't do, getting involved in a case that directly is related to her financial position on Ballard Partners. Hope you follow all that. Therefore, in addition to the reasons set forth in our original memorandum, the defense moves to strike the notice of intent and to dismiss the indictment because the Attorney General has violated the due process rights of Mr. Mangione by seeking the death penalty for Mr. Mangione in connection with his alleged actions against the CEO of one of her former firm's clients. The Attorney General's past and present financial interest in Ballard Partners, which continues to lobby the government on behalf of UHG and UHC, implicates Mr. Mangioni's due process rights because the very person empowered to seek his death has a financial stake in the case that she is prosecuting. Huge. The Attorney General has a personal financial interest in continuing to service her partnership, the sizable financial investment that she continues to have in that partnership, and the interest of a lucrative and wealthy client of that partnership. This personal financial interest caused her to engage in conduct that no prior Attorney General has ever engaged in: premeditated, purposefully, and fatally prejudicial statements and actions that directly led to the death penalty indictment in this case and the filing of a notice of intent. So what Karen is saying is she's financially invested in this, and her actions led to Luigi Mangione being given an indictment or a notice of intent to file the death penalty because of her financial interests being protected. In addition, the Attorney General represented to the Department of Justice, as a condition of her being considered for the post of U.S. Attorney General, that she would not personally and substantially involve herself in any matter involving a client of Ballard Partners for a year after her Senate confirmation on February 4, 2025. We read that statement she agreed to. Yet, the Attorney General engaged in the actions that are the subject of this motion less than 2 months into her tenure as Attorney General, when she ordered the line prosecutors to execute the man she believed killed the CEO of her former firm's client. It is hard to imagine, Karen says, something more personal and substantial than the U.S. Attorney General personally ordering prosecutors under her control to seek death-eligible indictment in a thing that she's financially invested in. I'm adding some of my own words. This is why I got it on screen, so you can read along. You can find out where I'm adding shit. I'm passionate about this, fired up. The Attorney General's personal financial interest in Ballard and Ballard's receipt of money from UHC/UHG violated the due process rights of Mr. Mangione. Any criminal defendant, let alone one who the government is trying to kill, is due a criminal process that is untainted by the financial interests of its prosecutors. Fuck yes. All day, every day, and all day, twice on Sunday, as we'd say in one of their cases we follow. All right. We need to speed this along because I'm a good half hour into this, and there's still another big point to make about that illegal arrest. Most of this is going to be about this, but we will get into the illegal arrest, and it does take some time. The Supreme Court has specifically cited the exact kind of problem that the Attorney General has created here as one of the improper factors that can deprive a defendant of due process. A scheme injecting a personal interest, financial or otherwise, into the enforcement process by bringing irrelevant, impermissible factors into the prosecutorial decision, and in some contexts raises serious constitutional questions. And she cites legal precedents why everything we're talking about has already been upheld by courts to be a major problem. Skipping on, perhaps the Attorney General's personal and ongoing financial interest in Ballard's is the reason why she disregarded the long-standing Department of Justice's policies and procedures in rushing to announce that she would seek to put Mr. Mangione to death. Perhaps her firm's close relationship with the employer of the deceased was the reason the Attorney General chose to make the public comments that violated local rule 23.1. And again, we're not going to get too into the 23.1. I've covered it many, many times. It's basically saying people can't make prejudicial statements if you're in a position where your statements can prejudice people. That's all. That's basically what it says. If you're a public figure involved in the prosecution of somebody, you cannot make prejudicial statements that would sway a jury. Is kind of a summary of how it says. I did it two different ways. All right. We do not yet know, because we have not been yet received discovery on these issues. Whatever the Attorney General's motivations, though, her actions in a case in which she has financial stake have violated Mr. Mangione's right to due process. So what Karen is saying here, and I broke it up in a weird way, is, by the way, I've already said I'm seeking a bunch of discovery. I'm going to go after to prove how much Pam Bondi was financially incentivized to do this. But right now, without that, we just have to assume that she probably did. But we're going to go after and prove it. Point B, the Attorney General's 3 public statements concerning her opinion of Mr. Mangione's guilt and the merit of seeking the death penalty against him are presumed to interfere with the due administration of justice. Now, this is a huge, huge point. And again, for people who don't like legal breakdowns, you've already tuned me out. But if you like legal breakdowns, here's what it is. It is presumed that people are prejudiced already. In other words, what the defense is going to say is we don't have to prove that the jury has been tainted or that people made poor choices because of Pam Bondi. We don't have to prove that. It is already presumed. The law, the court systems have already said if somebody does certain things, you can presume. You don't have to prove dick. You can presume if somebody did X, Y, and Z that somebody's constitutional rights have been violated. And that's what Karen's going to say. You can presume you've already done fucked up. You can presume that. We don't have to prove shit. It's by law, by definition. If you do these things, you can presume that you've ruined this person's due process rights. Hope you're following along. The Attorney General's public statements about Mr. Mangione and the merits of the death penalty are presumptively prejudicial. Presumptively, what does that mean? It means you can presume it caused prejudice. You don't have to prove anything. What she's going to say is the government's going to tell you that you can't prove that it did anything. You don't have to prove. It's presumed. So by seemingly ignoring our request to screen the grand jurors for prejudice and by proceeding with a grand jury presentation while Judge Ramos was clearly considering the defendant's motion, the government intentionally evaded any opportunity to identify and potentially cure grand jury prejudice. In other words, Karen and Nifolo made a motion during the whole seating of the grand jury that you can't have the grand jury being seated while Pam Bondi just talked about how they need to put him to death. She literally told the grand jury that was deciding whether or not Luigi Mangione should be put to death that yes, he deserves to be put to death. And therefore they came back with, yeah, we think he should be put to death because she told them that's how you should rule on this. And that was a major problem. And Karen pointed it out. You can't have the Attorney General telling the grand jury how they should decide on an issue while they're trying to decide on the issue. Second, the Attorney General's campaign to shape public opinion is unprecedented, historic, damaging, and prejudicial on its face. Even though the prejudice to Mr. Mangione is clear from the Attorney General's actions and the due process implications of her demonstrated conflict of interest, the court need not reach a factual conclusion as to the issue of prejudice because the local rules presume prejudice under exactly this situation. In other words, what she's saying is, Judge, you don't have to decide whether or not. You do not have to decide, Judge, whether or not the jury has been prejudiced against Luigi Mangione. You can presume it has. That's what the law says. There's nothing to think about. The law says if this happened, you can presume that they've been prejudiced. Rule 23.1, which was not addressed or so much as mentioned by the government in its opposition, provides that statements concerning the following subject matters presumptively presumptively involve a substantial likelihood that their public dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice within the meaning of this rule. There's a ruling. It flat out says what I just said. If you make those kind of statements in public, like Pam Bondi did, you can presume it'll prejudice a jury. That's what it says. The government does not dispute that the Attorney General is a lawyer participating in or associated with the investigation. That's one rule of 23.1. It has to be a statement made by somebody participating in the investigation. And even the government itself doesn't argue. Pam Bondi is in a role that makes her a lawyer participating in or associated with the investigation. After all, the Attorney General's April 1st, 2025 press release commenced the grand jury investigation leading into the indictment. So plainly, she is a lawyer participating in the investigation, and the government does not argue otherwise. Nor could it, because only the Attorney General herself can authorize the death penalty in a federal case. She is the single person responsible for making all final death penalty decisions, and thus, by definition, must be participating in or associated with the investigation. All of that to say, Pam Bondi meets the problem, the requirement 1 of 23.1, somebody that's involved in the prosecution. She is involved in the prosecution because she's the only one that can call for the death penalty. Second, the government does not dispute the fact that Attorney General called for a grand jury investigation to seek the death penalty based on 2 specific statutory factors. She publicly stated, 1, that Luigi Mangione's murder of Brian Thompson, an innocent man and father of 2, was premeditated, cold-blooded assassination that shocked America. That was her statement. Luigi Mangione killed an innocent man and father of 2 in a premeditated, cold-blooded assassination. You can't fucking do that. You can't do that. And she did. 2, after careful consideration, this is Pam Bondi's statement. She said, after careful consideration, I've directed federal prosecutors to seek the death penalty in this case as we carry out President Trump's agenda to stop violent crime and make America safe again. Unquote. And 3, she said, I was a capital prosecutor. I tried death penalty cases throughout my career. If there is ever a death case, this is one. And 4, that Mangione is, quote, charged with hunting down a CEO, a father of 2, a married man, hunting him down and executing him. And 5, I was receiving death threats for seeking the death penalty for someone who is charged with an execution of a CEO, unquote. The government's only response to all of that may amount to a, quote, technical violation of local rule 23.1. So the government's response when Karen said, oh my God, Pam Bondi cannot say any of the fucking shit she just said, their response, the government's response, the prosecution was, technically she might have been out of bounds, but judge, there's nothing wrong with it. Nobody was prejudiced. Bullshit. This judge in the federal case better do the right fucking thing. Better do the right thing. And that's not a threat. I'm not making a threat. I'm just saying we have no rule of law in this country if a judge doesn't rule appropriately. That would be a sham. All right. The government does not need to contest that her statements were opinions. I read it a little bit wrong. The government does not contest that her statements were opinions. So they do agree that Pam Bondi gave opinions. Clearly they were. The government does not contest that the statements were related to Mr. Mangione's guilt or the merits of the death penalty case, because she said so. Clearly they were. Accordingly, there is no factual dispute that the Attorney General's public statements were opinions about the guilt of Mr. Mangione, the strength of the evidence, and the merit of the death penalty case. As a result, there is a substantial likelihood that the Attorney General's public statements interfered with a fair trial and otherwise prejudice the due administration of justice pursuant to local rule 23.1. There's a reason why we have the law. She already violated the law. Karen Nifolo has pointed it out multiple times, and she's doing so again, imploring the judge to do the right fucking thing. This law was violated every way to Sunday, and you know it, and you don't even have to think about it. You just have to follow the law. That's all you have to do. You don't even have to think about it. It doesn't require a lot of deep thought. It's already been upheld. That's prejudicial, and you can presume it's prejudicial. In its opposition, the government looks to distinguish between what it calls actual prejudice. Here's where it gets crazy. The prosecution said, hey, it's not a big deal because she didn't cause actual prejudice. In its opposition, the government looks to distinguish between what it calls actual prejudice and the prejudice contemplated by a violation of Rule 23.1, arguing that actual prejudice, quote unquote, is the only thing that matters. Local 23.1, however, says the opposite. It is presumed. If you say that shit, you have prejudiced people. That's what Karen's trying to fucking point out. They're trying to say, oh, look, you have to prove. No, there was never any actual prejudice. It was just unintentional. And Karen is saying, no, the law literally says you can presume that person's been prejudiced. The government's refrain that the defense failed to prove actual prejudice is irrelevant. Prejudice can take many forms and can clearly exist even though not proven through traditional means. Certainly, it can take the form of a grand jury being swayed by a public statement. It can also take form of a grand jurors agreeing with the political sentiment that Luigi Mangione should be executed to, quote, make America safe again, quote, or it can take the form of an eventual trial juror or members of the public who, based on the Attorney General's public statements, believe that the safety of America somehow depends on executing Mr. Mangione. It's presumed. You don't have to prove that happened. You can presume that did happen. Prejudice can also take the form of a lawyer on a case spouting personal opinions on the guilt of the defendant or the merits of executing him. The due administration of justice is adversely impacted when a lawyer on a case, especially our country's attorney general, appears on television and assures the country that she was a capital crimes prosecutor, and if there ever was a death penalty case, this one is it. The prejudice to the due administration of justice stems from her position as the top law enforcement official in the United States, the lawyer in charge of the Department of Justice, the sole person who decides when the federal government seeks to execute someone and when it does not. So, when the Attorney General tells the world that in her opinion, Luigi Mangione should be executed, her opinion is unlike anyone else's because only she can actually make that happen. Also, her opinion carries the weight of the authority of her office and the Department of Justice as an institution. This is a bell that can never be unrung. You can't unfuck yourself from this mistake. She made a colossal mistake, and you cannot unfuck yourself is the universal translation of what Karen and Nifolo is saying. You done screwed up. These are public statements about cases that can never be fully managed or neutralized. This prejudice is, of course, not limited to the grand jury. It extends to the public and to potential trial jurors. The Attorney General's multiple public statements reached the widest of audiences and was repeated countless times in press reports and on social media, including accounts reaching millions of Americans managed by the government. This is why all lawyers associated with this case pending before this court have made a commitment to abide by our local rules. This is why we have Local 23.1 rule. These rules provide that when any lawyer involved in a case makes statements of the type the Attorney General made here, prejudice need not be proven. Rather, prejudice is presumed from the particular circumstances of and surrounding the statement. Yes, her and I are both saying over and over again, you can presume he's already been prejudiced. You don't have to make a ruling on this. You just have to follow the law. Because criminal defendants are presumed innocent, this is a big thing you're going to hear at the Devil's Advocates. You are presumed innocent until proven guilty in a court of law. You have to have you are presumed to be innocent. You're not presumed to be guilty until you prove your innocence. It's the other way around. You're presumed innocent until proven guilty. Because criminal defendants are presumed innocent, they must be acquitted unless the government proves guilt beyond a reasonable doubt. You need to understand where the burden of proof is. It's not Luigi Mangione's role or duty or requirement to prove to you he didn't do it. It's the government's job to prove that he did and he deserves to be put to death. A defendant may walk free solely by force of presumption. Listen to this. A defendant may walk free solely by force of the presumption. What presumption? The presumption of innocence until proven guilty. Because you are presumed innocent, a defendant can walk free solely on the fact that you are presumed innocent. Also, certain types of federal offenses carry the presumption of incarceration before trial, requiring a trial judge to incarcerate a defendant in the absence of any other facts. So, yes, there are circumstances many times when a person will be arrested and held while they're facing trial. So even though they're presumed innocent, there's still a law that allows them to be held temporarily while we decide if they really are as innocent as we say. And so what she's saying is a defendant who has not been convicted of any crime can be held in prison without bail solely because of the presumption. Rule 23.1 provides that prejudice exists so long as the predicate factors are established. In other words, The defense does not have to prove prejudice to show that the prejudice in fact exists. Rather, we just have to prove that 1, the Attorney General is a lawyer associated with the case; 2, that she publicly stated an opinion; 3, concerning the guilt of Mr. Mangione or the merits of seeking the death penalty of the case. Each of these predicated facts have been conceded by the prosecution. The 3 things we have to prove to say that you violated the law, that even the government has agreed happened. Those predicated facts have now been proven. As a result, this court must conclude there is no fact that, there in fact has been prejudice. Again, you can presume that he's been prejudiced. Because this happened, you can presume he's been prejudiced. So let me read that again. As a result, this court must conclude that there in fact has been prejudice to the administration of justice in connection with Mr. Mangione's case. This prejudice is now a fact, just like any fact. The U.S. Court of Appeals for the First Circuit has held that the amount of prejudice required to bring about a sanction in a death penalty case is lower than a non-death penalty case, stating, "We do believe that when stakes are so high, a smaller quantum of prejudice may justify a sanction." In other words, already 23.1 gives you a problem by what she did, but even more so when death is on the line. You don't even have to have as much evidence. You don't even have to have enough reason to think there was prejudice. If there's even a sniff that you've prejudiced somebody, when death is on the line, you must dismiss. That's what she's saying. All right, I got to try to speed this up. We're not doing well. That the First Circuit required a lesser degree of prejudice to justify striking a notion of intent is consistent with the Supreme Court statement that, quote, "When a defendant's life is at stake, courts are required to be particularly sensitive to ensure that every safeguard is obscured." And that, quote, "In capital cases especially, courts should be extremely careful how they interfere with any of the chances at life in favor of the prisoner." So you must try to give the prisoner the benefit of the doubt, and they didn't do so in this case. All right, we're going to try to wrap this up here, and then we'll get on to the illegal arrest part, and hopefully we can do that in about 15, 20 minutes. We still have to finish this, though. The Attorney General's 5 public statements over the course of 3 days were not errors. They are not unintentional deviations or something uttered in ignorance. They are just the opposite. They are part of an intentional and purposeful scheme to do 2 things. First, avenge the death of the CEO of her former firm's client and send the explicit message that when someone kills such a CEO, that she will use her new position as Attorney General to exact the most serious punishment possible. Second, use the Mangione case as the first where the new administration would seek a death sentence as a way of rolling out a new aggressive death penalty policy to shame the previous administration. In the words of the Attorney General herself, in the first day of the memorandum, "This shameful era ends today. Going forward, the Department of Justice will once again act as the law demands, including by seeking death in the appropriate cases and swiftly implementing those sentences in accordance with the law." Her statement was to basically shame the Biden administration for not putting people to death during the 4 years Biden was president. And that shameful era ends now. We will start executing people again, and Luigi Mangione will be our first poster child, is essentially what she said. The Attorney General's stated plan was to end one era and commence another, specifically where one where the death penalty will swiftly and decisively be pursued. Her actions in this case are the clear execution of her stated plan, leveraging the heavy media coverage around the Mangione case, including the leaks, the perp walk, the public commentary about the state of the healthcare in America. The Attorney General took the unprecedented and strategic step to commence a Southern District of New York grand jury investigation by way of a public press release. She followed this up by creating an Instagram page and posting additional false prejudicial information about the case. She followed this up with a national television appearance lobbying for Mr. Mangione to get the death penalty by referencing her own experience as a capital crimes prosecutor. Point C, and I think this is the last maybe major point, and then we'll move on to the final arrest. Where a death-eligible defendant has been prejudiced by the conduct of a government official, the district court has the authority to issue an appropriate remedy. So this is where she's asking for something to be done. There are at least 7 district court decisions, 5 from 2025 alone, striking the notice of intent. That's what Karen's saying. You must strike down the notice of intent and take off the death penalty. You can't put him to death. You've already fucked this up. In addition, as noted, there's at least 1 circuit court decision that held that a district court may properly strike a notice of intent upon finding of some prejudice. The government's argument that the Attorney General's decision to seek the death penalty is presumptively unreviewable. So they're trying to say you can't review Pam Bondi's statement. Sorry, what she did can't be reviewed. No judge can look into it. So Karen's going to counter that. The government's argument that the Attorney General's decision to seek the death penalty is presumptively unreviewable is not borne out in case law. District courts historically have closely reviewed death penalty decisions, as they must under decades of Supreme Court precedents, and have not hesitated, especially recently, to set aside the executive's death penalty decision when they are inconsistent with the defendant's constitutional and statutory rights or in violation of the court's local rule. These cases demonstrate the crucial role of the court in the administration of justice and death penalty cases. Far from being passive observers in the separation of powers balance, courts in death penalty cases have the most solemn of responsibilities to maintain the integrity of the process that may conceivably end with the execution of a person. Here's the last conclusion and what she's asking for. The appropriate remedy in this case is this. If the court concludes that the Attorney General's death penalty decision and her actions concerning this case may have influenced, in whole or part, by her past or present financial relationship to Ballard Partners and its clients, UHG and UHC, or that the Attorney General had a conflict of interest in this case should be dismissed. Holy shit. This is the motion to dismiss. If you find that she was financially invested in the execution of Luigi Mangione and could take financial benefit from whether he's executed or not, you must dismiss the entire case. And then she's going to add, but if you're not going to have the balls to do that, then you at least have to strike the death penalty portion and remove the intent to kill, or the notice of intent. So this is the big thing. She's asking to dismiss the entire federal case. And if she does so, listen, if for some reason the entire federal case gets dismissed, it leaves Luigi Mangione only facing second-degree murder in the state of New York. And that could be changed to manslaughter if Luigi Mangione changed his plea to something in the form of extreme emotional distress. It's an argument that says, yeah, maybe I did it, but here's why I did it, and you have to understand why. All of that whole extreme emotional defense or distress defense cannot exist as long as the federal government's case is proceeding. So Karen is asking for the entire federal case to be dismissed, and I think makes a great argument for. She's probably not going to win it because again, it takes major cojones to uphold the law, and a lot of people I just don't feel like have that ability anymore to uphold the law. But a judge should. Her argument is sound 100% to the end of the time. But in determining the appropriate remedy, the defense requests two things. First, we will be seeking discovery to the extent of the connection between the Attorney General and Ballard Partners as it concerns Ballard's relationship with UHG and UHC, and how this relates to the Attorney General's personal interest in advancing the interest of either Ballard's partners and UHG USC. Second, we will be seeking sworn direct testimony of all individuals with personal knowledge of the relevant matters. In other words, Karen says, we're not done. If you need supporting evidence, we're going to show you how much Pam Bondi's decision to execute Luigi Mangione or to order the execution of Mangione was a financial decision on her part. If the court concludes that the Attorney General's past or present financial relationship to Ballard Partners is, and its clients, USG, played no role. So if for some reason you as a coward, I'm going to word that. If you for some reason cowardly say, hey, look, just because Pam Bondi was going to financially benefit from the execution of Luigi Mangione doesn't mean that she was doing that on purpose. If that's the route you're going to take, that's what they're setting up. If you're going to rule that there was no problem with Pam Bondi having a financial interest in the execution of Luigi Mangione, then at a minimum, you still must remove the notice of intent. And here's why. If the court concludes that the Attorney General's past, present, and financial relationship to Ballard Partners and its client played no role, directly or indirectly, in her actions or decisions, and that there was no conflict of interest by the Attorney General, but that the Attorney General's public statements were prejudicial, the appropriate remedy is to strike the notice of intent. In other words, we've already laid out all day long, every day, why you violated 23.1. That's not even a question. So if you're not able to rule the fact that she had a conflict of interest, then at least admit that she broke 23.1, and therefore you must take death penalty off the table. If not entirely dismiss the case. Now, then we get into the whole statement about the part of the whole stalking and whether or not stalking is a thing. We're not going to cover that in this document review. The last thing that we are going to cover in it is going to be the illegal arrest and suppression of evidence, which we did have suppression hearings in the state case, but because Karen is currently fighting the federal case, she wants to talk about what's happening there. This is the Mangione's motion to suppress should be granted. We'll cover that here next. All right, so let's finish this last thing and see if we can do it in about 15 or so minutes. Mr. Mangione's motion to suppress should be granted. Now, again, this was 2.5 weeks or 3 weeks, depending on how you want to count it, of suppression hearings in the state case, which have not been ruled on. George Caro in the state case said he's not going to rule on whether or not it was a legal arrest or not in Altoona, Pennsylvania until May, possibly as late as May. Right now, the defense and the prosecution have time to file more motions and more papers for the judge to consider before making a ruling. I don't know why they need until May to make this decision. But while that decision is being made, the Karen is moving forward on the presumption that that is an illegal arrest and making the argument why it will be ruled as an illegal arrest in the state case. And so therefore, here is Karen's argument in the federal case: dismiss all of that evidence that was obtained in that illegal arrest. Let's try to make this quick. It's got some really cool points, and so I'll do it as best I can. Mr. Mangione's motion to suppress should be granted based on A, search incident to lawful arrest. Now, if you were watching my show on a live, I had an NYPD police officer break down different things like Terry frisks and Terry stops and when it's allowed to be done and when it's not, and whether it was legal arrest or not. So this show has a lot of really cool resources. Go back and watch that live. I think it was a Sunday night live when I wasn't there, when Robin and 1-1 from my show were breaking down, again, 1-1 being an NYPD police officer, breaking down his analysis of the body-worn camera footage. We're going to talk about other things, though, in this document, but I just wanted to tell you that you could get even more cool stuff out there. The search incident to lawful arrest. The government claims that the Altoona, this is Altoona, Pennsylvania, where Luigi Mangione was arrested 5 days after the shooting in New York. He fled New York, allegedly, because we don't know that Luigi Mangione is the shooter. He's allegedly the shooter. But if he did shoot Brian Thompson in New York, he fled and 5 days later was arrested in Altoona, Pennsylvania in an illegal arrest. And that's what his attorney in Pennsylvania has said. That's what his attorneys in New York have said. And that's what we're going to say here. The government claims that the Altoona officers were justified in searching through Mr. Mangione's backpack at the McDonald's because it was a search incident to a lawful arrest. This argument fails, however, because a search incident to a lawful arrest is limited to the arrestee's person and the area within his immediate control, construing that phase to mean the area from within which he might gain possession of a weapon or destructible evidence. So in other words, the Altoona officers are trying to argue that searching through Luigi Mangione's personal backpack to find stuff related to the crime and then make an arrest was illegal. So that's what the defense says. It was illegal. And the officers are trying to say, no, it was totally illegal because we were searching incident to arrest. We were going to arrest him, and so we were making sure that he didn't have any weapons on him. That's what we were doing. And Karen is going to point out, bullshit. You just said during suppression hearings in the state case just recently that you know damn well he had no ability to get a weapon. So you were not searching for a weapon to make sure that you were safe. That's bullshit. And she's going to call it out to the federal judge that they're liars in essence. That's what I'm saying. As is demonstrated from the body-worn camera footage, law enforcement moved Mr. Mangione's backpack outside of his immediate control approximately 17 minutes before he was arrested. For 17 minutes, Luigi Mangione was separated physically from his backpack. So, therefore, you cannot say we were searching his backpack because we were afraid he was going to go for a weapon in his backpack. Bullshit. You separated him from his backpack for 17 minutes before you arrested him. Therefore, you cannot believe he had any attempt to go for a weapon in his backpack. And in fact, she's going to point the officers actually admitting they know damn well he could not have gone for a weapon, therefore negating the entire fucking argument. Mr. Mangione was rear cuffed, separated from his backpack by at least 5 officers, with another 7 officers in the immediate area in the back of the McDonald's. That backpack was not in Mr. Mangione's immediate control at the time of his arrest, was further established by the testimony of Altoona officers at the recent suppression hearings conducted in the state court. Again, this is a federal document being filed, but she's talking about the recent suppression hearings in the state court to say, look, these officers admitted the very bullshit that they're trying to say that they didn't do. For example, Lieutenant Tom Hanley, the highest-ranking law enforcement member at McDonald's, where Mr. Mangione was arrested, testified that he did not tell officers to move Mr. Mangione further away from his backpack at the time of the search because he did not believe it was plausible Mr. Mangione could access his backpack while rear-cuffed and surrounded by officers. That is huge. Here's the questions and answers from the state suppression hearings. Question. And Mr. Mangione was formally arrested and searched ultimately by Officer Fry and Detweiler, correct? Answer, yes. And at the time that he was formally arrested and taken into custody, Officers Fry and Detweiler searched Mr. Mangione, did a more in-depth search of his clothing, correct? Answer, yes. They removed his outer layers of clothing, to conduct a more thorough search. Question. And at what time did you, and at that time, did you not tell anyone to move the backpack further away from Mr. Mangione while they were conducting the search, correct? And he says, that's correct. Question. And didn't you tell officers Fry and Detweiler to move Mr. Mangione away from his backpack and do the search elsewhere, right? Answer. Correct. Question. Because you had no concerns that he could access it, correct? Answer. Yeah. I didn't think that was plausible. Question. Because he was cuffed and he was rear cuffed, correct? Answer. Yeah. He had been cooperative up to that point. Question. And he was in handcuffs, correct? Answer. Yes, he was in handcuffs. Yes. So, what did that just establish? You tell me you searched his backpack because you were afraid he could have gone for a weapon, while simultaneously saying, look, I didn't have any fear Luigi Mangione could go for a weapon because his hands were cuffed behind his back and he had officers between him and his backpack. There was no concern he could go for a weapon, while simultaneously trying to tell us we were searching his backpack because we were afraid he could go for a weapon. But you just stated multiple times we didn't have any concern he was going to go for a weapon because he was handcuffed behind his back and surrounded by officers. There was no concern. Similarly, Sergeant John Burns, the second highest ranking law enforcement officer at the McDonald's, testified that Mr. Mangione was not in control of his backpack at the time of the search and arrest. Well, let me break it down for you. Question. At the moment when Officer Wasser and Fox were going through the backpack, Mr. Mangione was not in control of his backpack, was he? Answer. That's correct. Question. He wasn't holding it, right? Answer. No. Question. In fact, he was handcuffed, so he couldn't reach it, right? Answer. Yes. Question. And there are officers between him and the backpack, right? Answer. Yes. You know he couldn't have gone for a weapon. He was handcuffed behind his back and had officers between him and his backpack. You cannot say we were searching the backpack to make sure he couldn't go for a weapon. Another officer, Patrolman Samuel McCoy, started searching Mr. Mangione at the time of his arrest. As with Lieutenant Hanley and Sergeant Burns, McCoy also testified that Mr. Mangione was separated from his backpack and surrounded by officers at the time of his arrest and the search. Question. And the time when Mr. Mangione was being searched, it is you, Detweiler, and Fry searching him, correct? Answer, yes. There's Fox and Wasser doing the backpack, correct? Answer, yes, sir. Question. And these other officers that you mentioned, Hanley, Christ, Burns, Trent, Miller, they were all in the area, correct? Answer, I believe they were still at the McDonald's, yes. Question. At this point, again, is he rear cuffed, right? He's rear cuffed, right? Yes, it's our policy that unless it is a female that is actively pregnant, they are to be cuffed behind their back. Question. And there are several officers around him, correct? Answer. Yes, sir. Question. So you weren't concerned that Mr. Mangione was going to kick off his sneakers, evade the officers, and try to open his backpack with his feet, were you? I love that. Answer. No, because we had good body positioning. Oh, so you blocked him from getting to his backpack. Question. And you were separating him from his backpack, correct? Answer. Correct. All day long and every day, she got them to admit, you guys knew he was separated from his backpack and had no chance to get to his backpack. There was no plausible way you could imagine he could get to his backpack. So telling us you were just concerned for the safety of your officers, and that's why you were searching his backpack for weapons and things like that, because he might go for it. You know it's a lie. You say over and over again, you know he had no chance, no plausible chance to get to his backpack. There was no plausible chance. Given the body-worn camera footage and the law enforcement's testimony at the state suppression hearings establishing that the backpack was not within Mangione's immediate control at the time of his arrest, there is no basis for the government to argue that the backpack search at the McDonald's was legal as a search incident to a lawful arrest. Because they're saying, look, we might be arresting him, and so therefore we can search to make sure he doesn't have anything on his body. But you know that's not true because he had been separated from his stuff. There was no concern or worry about your officers, and you had multiple officers admit that we had no concern of him going for his backpack because he was separated from his backpack and his hands were cuffed and he had good body positioning with officers between him and his backpack. Nevertheless, the government argues that handcuffs are not fail-safe, and neither the use of handcuffs nor the presence of law enforcement officers eliminates the possibility of a defendant gaining access to the items in his vicinity. So that's their argument. Look, even though we have 11 police officers there and about 7 of them between him and his backpack, and he's cuffed behind his back, facing the opposite direction of his backpack, it's not impossible that he could have somehow gotten past us all and gotten to a weapon. So that's why we went ahead and did that. Bullshit. As noted above, the body camera footage and the suppression hearing testimonies irrefutably confirm that at the time of his arrest and search, Mr. Mangione was rear cuffed, was separated from his backpack by several feet, and surrounded by 3 officers while 2 others searched his backpack, and while there were 7 other officers in the back of the McDonald's. So, search for a bomb argument. We're almost done. The government next claims that even if the backpack search at McDonald's was not justified as a search incident to lawful arrest, because they're admitting, fuck, Maybe it wasn't, but even if it's not, we were looking for a bomb. That was their argument number 2. So the government next claims that even if the backpack search at McDonald's was not justified as a search incident to lawful arrest, the search was still proper because the Altoona Police Department officers could have reasonably believed that the backpack may have contained some immediate dangerous instruments. In making this argument, the government relies on Patrolman Wassers, that's Christy Wasser, I believe, female, stated that she was searching the backpack at the McDonald's to make sure there were no bombs in the bag before taking it to the station. But contrary to the government's argument, the totality of circumstances demonstrates that Wasser's claim about a bomb was blatantly false and pretextual justification for conducting an evidentiary search. Most notably, the body-worn camera footage establishes that this was a search for evidence, not for search for a bomb or a dangerous instrument. For example, this is huge. One of the first items that Patrolman Wasser took from the backpack was a bag too small to carry a bomb. As Wasser acknowledged at the suppression hearing, she did not believe that there could be a bomb inside that small bag. Nevertheless, Wasser opened the bag and removed a phone and passport that were inside. Rather than returning the passport to the bag and continuing her search, as one would expect if she was searching for a bomb, Wasser instead gave the passport to another officer at McDonald's to assist in the Altoona's false statement forgery investigation and the NYPD NYC shooting investigation. Wasser then moved to an envelope also too small to contain a bomb, which she examined before returning it to the backpack. Wasser also searched through a wallet that she recovered from the backpack, another item that is obviously not a bomb or a dangerous instrument. Additionally, during the search, Patrolman Fox used a knife to slice open a small cardboard container too small to contain a bomb, a fact that the Patrolman Fox himself admitted during the hearing. Question: did you think there was a bomb wrapped in that card stock that you opened with a knife? Answer: no, I could tell it was some type of data chip. I just wasn't sure. So he's admitted, I know damn well there wasn't a bomb in there, but I was searching it, and then we're going to tell you we're searching for a bomb. You know there wasn't a bomb. You used a knife to open a piece of cardboard. You admitted, no, I didn't think there was a bomb in that piece of cardboard. Then what are you doing exactly besides an illegal arrest, an illegal search? Sorry for my light. I just unplugged my light. Sorry about that. Despite knowing that this container did not contain a bomb, Patrolman Fox nevertheless opened the container hoping to recover evidence to support the NYPD investigation into the New York shooting. They were searching for evidence to make an arrest is what they were doing, which is illegal. That's what she's arguing. It's illegal. They're going to try, we were doing a bomb search. We were doing a search incident to arrest to make sure we were safe. Bullshit. You were looking for evidence on the guy. That this bomb search was pretextual is further demonstrated by the fact that once Patrolman Wasser found the loaded gun magazine in the backpack, Patrolman Fox stated to Wasser, now that we've found that, let's just take it back to the precinct. If this truly were a search for a bomb, officers would have continued searching the backpack before taking it to the precinct, especially considering that neither Wasser nor Fox had had searched a third compartment of the backpack for a bomb. So in other words, you're saying you're searching for a bomb, but you immediately stop once you find the gun magazine and say, oh shit, we need to take this back to the precinct to search it. And you stop your bomb search. So there never was a bomb search. You weren't looking for a bomb, or you would have continued to search those pockets that hadn't been searched yet. Instead, because this was an evidence search, that's what Karen's saying. You're not searching for a bomb, you're searching for evidence. Altoona officers stopped searching the McDonald's once they found incriminating evidence and took the backpack back to the precinct. Once they found the evidence they were looking for to arrest him, then they stopped searching. But they shouldn't have been doing that in the first place. They were using illegal loophole of saying they were searching for a bomb when they clearly were not. Here's a footnote. Patrolman Fox's admission that she searched the cardboard container despite knowing it was not a bomb, that he, wasn't a she. Patrolman Fox's admission that he searched the cardboard container despite knowing it was not a bomb is not surprising, given that his earlier testimony that the main reason he was searching the bag was because he was conducting a search incident to lawful arrest. So you're trying to have it both ways. I'm doing a search incident to lawful arrest. I have the right to do that. Okay, no, you didn't. Okay, well then we were searching for a bomb, but you already said you were doing a search incident to lawful arrest. You are fucking yourself all day long, every day. Like I said, he said, the bomb threat is always there in the back of my mind, no matter what bag I'm searching. I'm searching his bag incident to arrest. The threat of a bomb is also there, or a threat of any device that can cause harm to human life. But that's not the sole reason I'm searching the bag. I'm searching that bag incident to arrest. As demonstrated above, there was no legitimate basis to search the backpack incident to a lawful arrest. In inevitable discovery through inventory search, we're almost done. The government lastly claims that even if the backpack was improperly searched, the evidence should nevertheless be admissible because the evidence would inevitably have been discovered pursuant to an inventory search in light of the defendant's arrest. This argument relies on the government's claim that Patrolman Wasser conducted an inventory search of Mr. Mangione's backpack at the station. However, the suppression hearing evidence makes clear Patrolman Wasser's search of Mr. Mangione's backpack was a search for evidence and not an inventory search. First, Wasser stated this search on a metal folding chair in the corner of the intake section at the precinct where there was no room to empty the numerous items from the backpack and take an inventory. Second, the search consisted of Patrolman Wasser reopening the same backpack compartment that she had started searching at McDonald's before immediately closing the compartment and opening the front compartment of the backpack, which she claims she had never searched the McDonald's or during her 11-minute drive to the precinct without body camera on, as if she were specifically looking for the gun. This is consistent with an evidence search, not an inventory search. Third, after finding the gun, Patrolman Wasser continued the evidence search in a hallway at the precinct. During this search, Patrolman Wasser removed all the items from the backpack without taking any inventory. All Patrolman Wasser did during this search was separate items of evidence from personal items before placing the personal items back into the backpack without making a list or inventory of any of the items that were removed from the backpack. As described by Sergeant John Burns, who was present for part of Wasser's search in the hallway, the search was merely to remove any contraband or suspected weapons or items like that. That is not the procedure for an inventory search. While law enforcement and the government attempt to portray this as a search for inventory, the testimony regarding this search demonstrates that it was a search for evidence and not to produce an inventory. As the Supreme Court has ruled, however, an inventory search must not be a ruse. An inventory search must not be a ruse for generally rummaging in order to discover incriminating evidence, and that an individual police officer must not be allowed such latitude that an inventory search is turned into a purposeful and general means of discovery of evidence of a crime. That's exactly what Wasser did. She said she was doing an inventory search while looking for evidence to arrest and have a crime. And given that Patrolman Wasser's purpose in searching the backpack was to separate evidentiary items from personal items without making an inventory of what was actually in the backpack, this search cannot be considered an inventory search and cannot be basis to admit the backpack evidence under the doctrine of inevitable discovery. And here's the last conclusion. For this reason stated herein, Mr. Mangione's memoranda stated on September 20th, 2025 and October 11th, 2025, the incident should be dismissed. The government should be precluded from prosecuting this matter as a death penalty case, and the evidence unlawfully seized and statements obtained in violation of the memoranda must be suppressed. Everything, she's already filed multiple documents. September 20th and October 11th, she states there, she's already said multiple times this was an illegal arrest. And that judge still wants to, in the state case, wait until May of 2026 to decide whether it was an illegal arrest or not. She knows it's an illegal arrest, and that judge is waffling. And she's saying, look, I've already filed a bunch of reasons why this is illegal. You know it's illegal. You don't need until May to rule it. Toss the federal case and make it a state case only. Hope you understand the nuances. Hope you understand this legal breakdown. I realize it's a lot of nuance. And at the end of the day, remind you, you have the presumption of innocence until proven guilty in a court of law. The big issue, the legal defense strategy, in my opinion, is to work on getting the federal case tossed out so that all Luigi Mangione is facing is the state case, which is second-degree murder. And if that happens, if there is no federal case, and they can get it tossed, and I don't know, that seems like a Hail Mary, but if they could get it tossed and all Luigi Mangione is facing is second-degree murder in the state, they could put the healthcare system on trial in America and say, maybe our guy did it, but you have to understand why he did. But if they have the federal case, they can't even make that argument, which is, again, why they say it's unfair to Luigi Mangione. The argument that they would present to the state is different than that they would present to the federal government. They're trying to get the federal government case tossed. Let's talk about it in detail. Let me know how you feel. Is it just a technicality? Is it bullshit? Or do you like the nuances of the law? And how do you feel about putting the American healthcare system on trial? Let me know what your thoughts are. Have a good day.